In Webb, I covered how complaints that are defective on their face can be tossed in Illinois without the expense of pre-hearing matters such as discovery or a trial. This process is designed to weed out the crazy lawsuits that are often filed by various people and entities. But what happens when the lawsuit has a defect that isn't apparent on its face? Well, the cousin of 615 is a 619 motion to dismiss, and those motions say, hey, there's a separate matter out there that makes it impossible to win this lawsuit. Now, 619 lists 8 specific examples with a 9th one that sort of acts like a wild card, i.e. the mysterious affirmative matter. Today's case is a great example of that 9th factor. A next of kin sues a law firm on behalf of the deceased, and just one problem: because the alleged malpractice occurred after the decedent had passed, and any lawsuit must be brought by the executor or representative of the estate, which none of the plaintiffs were. The defendants argue this outside matter called standing, which is not indicated on the face of the complaint, defeats the lawsuit. First, as a matter of good briefing practice, the defendants committed a faux pas of sorts. They included the issue of standing under 619, but also argued that the plaintiffs failed to state a cause of action that would entitle them to relief, which falls under 615, and this was all done under the same count. That's called commingling counts. Most of the time, the judges don't care, but in civil procedure, there's always a but. The appellate court notes that the statute is clear. You must separate the counts and identify whether it's under 615, 619, etc. The failure to do this may result in the denial of relief. However, if the commingling of counts does not prejudice the responding party, the court can sort of, look the other way. Now, prejudice isn't spelled out here per se, but the rule of thumb is that if the plaintiff knew what the defendant was trying to do and was given a chance to argue it with the trial judge, that probably isn't going to result in prejudice. So in this case, although the defendants misstepped in their motion practice, no harm, no foul. Now, turning to the merits of the 619 motion, the defendants are saying, hey, they don't have standing. Standing is a fancy way of saying that the plaintiff has some vested interest in the outcome. Example, if I steal my neighbor's car, that neighbor has standing to take me to civil court, but the neighbor's mother, who holds no title to the vehicle, does not. Standing can be a slippery thing in Illinois, so case law defining what it is somewhat broad, but the idea is best summed up like this: the person suing must have a dog in the fight, or skin in the game, if you will. So applied to this case, step 1 is that under case law, the lawyer is generally answerable to the client and the client alone. 2, the deceased was purportedly injured financially the day after they passed away. 3, standing is an affirmative matter that you're allowed to raise under 619A9 per case law. 4, only the executor of the estate can bring suit on behalf of the decedent, which brings us to 5, none of the plaintiffs are that. So this matter, which is outside the 4 corners of the complaint, means any trial would be a waste of time because, again, the plaintiffs are in no position to sue on behalf of the deceased. So the case was properly thrown out. Anyways, that's all I have. Thanks for watching.